Welcome everyone to our keynote conversation in which we're going to take on the modest task of covering the past, present and future state of religious freedom in America in 90 minutes. We'll be asking whether religious liberty really is under threat. What, for example, do ongoing battles over the contraception mandate in the healthcare law say, if anything, about the state of religious freedom? And if it is in the sort of decline that some are suggesting, what can and should be done about it? Well, joining me, I should introduce myself, I've forgotten, sorry. I'm Jane Little. I used to be the religion correspondent for the BBC. I cover religion and politics a lot. I work out at the BBC Washington Bureau, and I write on religion quite often. So joining me, I have three people who are very well known, have made public and distinguished contributions to the debate already and need little introduction. Judge Ken Starr is the president of Baylor University, a constitutional law professor, former Solicitor General of the United States, author and expert on the religious clauses in the First Amendment. We have E.J. Dionne, familiar on campus as a professor in the Foundations of Democracy and Culture. He's a fellow at the Brookings Institute, author, columnist for the Washington Post, and writes and speaks frequently on religion in US politics. And next to me, we have Ross Douthat, who is a columnist for the New York Times, author of the book most recently, Bad Religion: How We Became a Nation of Heretics, and has written a lot about recent controversies on the contraception mandate, gay marriage, Chick-fil-A, and how they infringe on religious liberty. So I'm going to invite each of them to spend just a few minutes sharing their thoughts, and then we'll discuss, and after that we'll invite questions from the floor. So, Judge Starr.
Well, thank you, and it's a great privilege to be here. My thanks to Georgetown and the Berkeley Center for this opportunity. I guess I would get the ball in play by saying, first, I'm a cheerful optimist. There are always tensions. There are always threats to liberty. We're to be vigilant. Liberty is always not a given. We have to, as it were, earn it or at least protect it. But the reason is, at least in the United States, especially when we consider what has been said in the course of this conference, is I think there is a societal consensus in the United States. I think so. My two colleagues may very well disagree. And that is freedom of conscience and belief, as well as freedom of worship. When we go back to the soaring language of Justice Robert Jackson, the West Virginia Board of Education versus Barnett, the two Barnett sisters kicked out of school because they would not, as young but nonetheless devout Jehovah's Witnesses, participate in the flag salute ceremony. The Supreme Court, albeit divided 6-3, but in very soaring language, which is really part now, I think, of our constitutional culture. Justice Jackson said, and I should quote it, but he began, if there's any fixed star in our constitutional constellation, he knew how to write. And it is that, and this is almost a quote, that no official, no matter how high or petty, can, he used the word prescribe, and he used the word coerce, that which is orthodox. And then he set forth, not just in religion, but in politics and so forth. Now, even though there were 3 dissenting votes, including truly a remarkable dissent by Justice Frankfurter, a dissent in sorrow, it was a lamentation, and a very eloquent lamentation. I think that settled it in terms of the constitutional culture, which I think has seeped into the broader culture. This is the Supreme Court as teacher. The second thing where I think there is, while perhaps a grudging consensus, it certainly is a consensus in our constitutional structure, and that is equality, the non-discrimination principle as applied to the religious voice. Thou shalt not exclude the religious voice from the public square. There are those who think the public square would be a lot better off without it, and to let that policy debate go on as to whether society would be better. But this is bedrock in our constitutional jurisprudence. And here there's unanimity. The Supreme Court is unanimous on this, and it's gotten a little bit out of sorts with those who didn't get the message and read the memo. Don't discriminate against religious voices. Now, note equality. I could talk about neutrality, but let me cease and desist by saying the equality principle demonstrated by, among other cases, the Bridget Mergens case involving, and this is a very important part of the conversation, when the courts rule in a way that is seen by the Congress of the United States, cutting across political lines, as inimical to religious liberty, Congress steps in and smashes, to the extent it can, that decision is illiberal. And the Equal Access Act smashed down those exclusionary decisions in the lower courts that said, if you want to start a Bible club in the local public school, forget it because of the Establishment Clause. And the Supreme Court, building from free speech jurisprudence, said the equality principle applies here as well.
EJ.
I want to say a couple of things. First, I didn't know that Jane was the moderator of this panel. I would do a panel on cricket, which I know nothing about, and would make an absolute fool of myself on if I had known Jane was the moderator, and now I've just invited really, really tough questions from her by saying such a thing. I also want to honor my friend Tim Shaw, the Berkeley Center in general, and Tim Shaw in particular. I'm very proud. Tim wrote most of his PhD thesis outside my office at Brookings, so I hope some of his brilliance rubbed off on me. And I feel like I'm sitting between Burke and Thomas Aquinas with a column here, which I guess would kind of make me Tom Paine or Gene Debs, except that's unfair to Paine or Debs. But I'm really looking forward to this conversation. I'd like to begin by suggesting the following, that any country, I'm loud enough. Any country that has a court case about whether you can say prayers before a football game, I think really honors and cares about religious liberty. Now, some might say that also shows how much we revere football. But I think that there are times in this discussion where we totally forget who we are. And when I hear kind of overheated language about threats to religious liberty in the United States, I ask, compared to whom? Compared to what other country on earth? There aren't many countries that actually have a First Amendment which invites a series of arguments about what the definition of religious liberty is, but which clearly enshrines it as a central principle in our republic. And so I worry a lot at this moment that an issue on which there is quite a lot of consensus among Americans gets defined instead by those areas where we don't disagree about religious liberty nearly as much as we disagree about how to define it. In particular, how each half of the religious clause of the First Amendment fits together. One of the questions I used to ask students in my religion and politics class was basically, does the Establishment Clause reinforce or conflict with the Free Exercise Clause? And I think you can have a very interesting argument about whether they reinforce each other or whether they are sometimes in conflict. I think a lot of court cases are based on a concern that they sometimes conflict, and we have to make choices. A couple of examples of where a consensual approach is possible on this. When you go back to the Clinton presidency, one of my favorite documents ever to come out of that presidency was a document on religious liberty in the schools. And the administration called in all kinds of people, ranging from the ACLU to a lot of groups among religious conservatives, to say, look, where can we agree here? Because a lot of school principals, a lot of teachers were so worried about the First Amendment that they were enforcing restrictions on religion, on religious practice, on religious displays by students that are nowhere demanded by the courts, nowhere demanded by the First Amendment. And the result was that it defined liberty rights that students had in school. You could bring a Bible in, you could wear religious garb or a cross or a Star of David. And I think that we might begin not by starting with a religious war but by starting with a search for the consensus that I think is quite broad on this. Two other quick points. I know we're going to talk about the contraception mandate at some point. Just so you know, when the administration came out with its initial rules on this, I was very critical of the administration because I thought the exemption was too narrow. So for about 2 weeks of my life, I was a hero to the right wing. That only lasted about 2 weeks because
I sent him fan mail every day. Every day, a new envelope, different color.
Every time Ross sent me another letter, I said, "Are you sure you're right in what you just wrote?" I'm speaking of myself. But when the president came and then began to offer an accommodation, I got very upset with my temporary conservative allies because I thought this is a genuinely difficult question of rights in conflict, which is I do believe that the religious institutions were entitled to a more robust exemption. But I also thought that we needed to take seriously the religious rights of employees of large religious institutions who expected to have contraception coverage in their health plans. I also got very disturbed by the way in which contraception got allied with abortion. Now, I'm Catholic. I understand how the Catholic Church links the two. But I believe these are two quite different things. And there was a very robust exemption on abortion. And I think when the bill was passed, no one who voted for the robust exemption on abortion expected a really tough exemption on contraception. So I think that is an issue where some consensus ought to be possible in principle. Last quick point, I do think we need to talk about the religious liberty of Muslims and other religious minorities in the United States. Because when you think about the First Amendment, it's designed to guarantee everybody's religious liberty. But it was particularly designed with religious minorities in mind, like those Baptists around the country who were struggling with established churches in the states. And while, again, I do believe our Muslim brothers and sisters in the United States have substantial religious liberty, I worry about the ease with which people can say things that are sort of openly anti-Muslim. The controversy over the community center in Lower Manhattan, AKA the mosque near Ground Zero, I thought was very disturbing. That didn't feel like who we are as Americans, a nation of religious liberty. And lastly, we want to set an example on this for the world, not only for the formal religious liberty we allow, but also for the spirit of liberty and pluralism that we embody. And I think episodes like that are not good for religious freedom, and they're not good for us as a nation.
Ross.
Well, first, thanks so much for having me. It's an honor to be in such distinguished company on this panel. And EJ asked me before we began, he said, we've done a lot of events together, but I'm genuinely curious what you're going to say on this front. And I said, well, that's why I asked to go third, so that I could see whether I should play the optimist or play the pessimist. And I can take either track. But since Judge Starr and EJ both waxed positive, I guess I'll be slightly more negative and then try and turn in a slightly more optimistic direction at the end. I think that while I agree, and indeed deeply agree, that the United States has an unparalleled historic commitment to religious liberty that endures and is in overall very good shape to the present day, I do think it is worth thinking about in sort of political philosophy terms for a minute. There is one kind of seam within that understanding of religious liberty that goes all the way back to, in certain ways, the father of Anglo-American liberalism, John Locke, which is this question of whether individual religious freedom also applies in sort of corporate terms. And Locke, of course, was famously a champion of religious toleration, wrote eloquently on that front, but was not a champion of religious toleration for all groups. And in particular, he was not a champion of political toleration for Roman Catholics in late 17th century England, for understandable reasons, given the political and religious disputes of the time. But the sort of implicit and explicit arguments that Locke made about Catholic loyalty to the Roman Catholic Church and sort of how that played out in political terms and so on, I think have remained as a kind of sort of buried element in our religious debates that tends to bubble up to the surface often when the Catholic Church in the United States in particular comes into conflict with civil authorities. And obviously this was true in a much more pronounced way in the late 19th century in debates over the Blaine Amendments and sort of educational policy. But I think it's also been true over the past couple of years in the debates about the contraception mandate. And I think it may well become even more pronounced in ways that extend in broader ways to encompass Protestant and Jewish institutions even more as well in future debates about marriage law and gay rights and how the possible sort of constitutionalization of gay marriage ends up impacting religious institutions, schools, and so on. And the issue here is just the question of what is the religious liberty that the First Amendment guarantees? And I think everybody, or practically everybody, left, right, and everywhere in between, agrees that that the First Amendment guarantees a freedom of worship, right? It is simply unimaginable to me that we will ever live in an American republic in which people are, with the exception of obviously religions demand human sacrifice and these sort of crucial First Amendment gray areas, that we'll ever live in a country where that right, the right of sort of congregations to hold to particular theologies and hold particular liturgical celebrations and so on, is ever challenged. The question is going beyond that. What does the free exercise of religion mean? And in particular, does that free exercise clause guarantee something broader to religious institutions that are not necessarily churches holding worship services, but are, let's say, large employers running hospitals and charitable institutions and so on? And from that perspective, I think what was troubling to a lot of religious conservatives and to EJ originally before the Obama White House changed its position in some form was the distinction that the White House policy was drawing, and we can talk about whether they continued to draw that distinction after they changed the policy, between churches who had one particular set of rights under the First Amendment and, say, Catholic hospitals, or ultimately perhaps evangelical colleges or charitable organizations and so on, who had a more restricted form of religious freedom. And I think the reason that distinction was troubling is because, in part, if you look at both the American religious present and the likely American religious future, at least given the trajectory we're on, it's America, as we are today, is a country that is, I think, as religious, arguably, as we've ever been, but less institutionally religious than we've ever been, maybe not ever before, but certainly in the last 50 to 75 to 100 years. And so in the popular conception, where a sort of do-it-yourself spirituality has more play and sort of institutional religious commitments have less influence, I think the argument that the First Amendment protects freedom of belief, freedom of sort of intellect, and freedom of worship, but not necessarily freedom of religious sort of activism, action through hospitals, charities, and so on, is more powerful today than it would have been a couple generations ago, and may become more powerful. And you can imagine a kind of feedback loop, and I think you actually saw this in the contraception issue, where I think the Obama White House's policy would have been unimaginable politically in a world where the Catholic Church hadn't just passed through 10 or 15 years where, thanks to the sex abuse crisis, it was a sort of period of sort of self-inflicted wounds that dramatically weakened the church's public witness and political influence. I think, to go back to the Clinton era, you can't imagine President Clinton picking that kind of fight with the Catholic bishops, because as an institution, the Catholic Church was stronger then. And so you can imagine this sort of feedback mechanism where institutional religion gets weaker, the claims of the state advance to fill that gap, and that further weakens religious institutions and so on. And I think all of us, liberal, conservative, secular, religious, have good reason to see the particularly important role that institutional religion has played in the US over the last 250 years, and to worry about any kind of cycle that sort of that weakens the churches and synagogues and mosques' ability to play that role in the future. And so that's sort of the case for a modest pessimism. And to end on a slightly more optimistic note, I do think that to religious observers, particularly religious conservatives, who leap from that pessimism to a sort of deeper vision of real persecution. I think actually the history of the Catholic experience, not only in the US, but going back hundreds and thousands of years, should be instructive, that actually there's a lot of space between perfect religious liberty and back to the catacombs persecution. And I think even if we get in this sort of negative cycle, look, from a Catholic perspective, passed through centuries where the church had to deal with kings appointing bishops and handing dioceses to, sort of shiftless nephews of dukes and all the rest of it. I mean, the church the Catholic Church has dealt with these kind of challenges before in ways that have not necessarily led to martyrdom and persecution. I think that's more what we're likely to see if my pessimistic scenario is correct, and just a sort of low level church-state struggle that doesn't necessarily lead to truly negative or truly disastrous outcomes. And I went on a bit long, but thank you.
Jane, may
so
I
much.
comment just for a second?
Sure.
And respond? Because, Ross, I think you should be more cheerfully optimistic. Notwithstanding some of the pressure points.
This is not a dynamic I expected, I will say.
Me neither.
And the struggle right now on the contraception mandate and the Hobby Lobby litigation is over exemptions and who creates them. And that raises, of course, very profound issues of democratic theory. Do we want the courts in that business? Many people say, yes, we sure do. And that's true for judicial liberals of yesteryear. William Brennan, Thurgood Marshall would say, yeah, that's what we're here to do. Moderates, Justice O'Connor would agree. But it really was, quote, the judicial conservatives said, we're really worried about this, especially creating these special tests, strict scrutiny, and the kind of lawyer talk that people engage in. But what that process means is that it's judicial power, and it's the judgment of 5 justices who determine whether a particular activity will be exempt from positive law. Well, that's huge. Well, Congress steps in all the time with respect to these exemptions. And so what's a little odd about the conversation over the HHS mandate is that we have the administration, we've got the Article 2 branch acting under delegated authority, right, under the Affordable Care Act, but we really haven't had a full conversation. Now, Congress did, once upon a time, not so long ago, pass the Religious Freedom Restoration Act, which the Supreme Court ruled unconstitutional, but only people overread that, only as applied to the states. And so the Congress, once again, cutting across bipartisan lines, came together and signed into law. It didn't matter what party you were in. You supported what? Religious freedom restoration. The courts have gotten it wrong. So what do? We step in. And see, that's what I think the Hobby Lobby litigation is all about. Can
Which is
mandate,
the for-profit case we're looking at now that the government's taken to the Supreme Court saying,
well,
look at this, this man
right.
wants an exemption for a corporation. So it's taking it into a whole new area. Ross
That's
touched
right.
on
Who
that
has
earlier.
religious freedom is but part of this, what does RFRA, I hate to use an acronym, but welcome to Washington, the Religious Freedom Restoration Act apply at all? But the final thing I want to say in response to Ross's guarded pessimism is that parachurch organizations enjoy robust liberty protected by the Constitution, as reflected by the Supreme Court's unanimous decision last year in the Hosanna-Tabor case involving a church, so a very evangelical Lutheran church, which fired a teacher who had invoked her federal civil rights under the Americans with Disabilities Act. That's a pretty serious conflict, isn't it? Yet the Supreme Court embraced what had developed in the lower courts. Congress hadn't spoken to us, the, quote, ministerial exception. So that must be a priest, a rabbi, a pastor, or whatever. No. This was Cheryl Parrish, bless her heart, a teacher who was not a lay teacher. She was called. And in Lutheran theology, as I understand it, that means we have ordained you to teach these little children. Now, interestingly enough, and this is where there are tensions in the polity, not just in the culture, the EEOC and the Justice Department took quite a secularist position. When you go back, the lawyers do these kinds of things, you read the briefs, well, how did the government lose 9-0? How did that happen? Well, it was an unwillingness to take a bit more seriously the great weight of both the Establishment Clause and the Free Exercise Clause. The government had managed, in its enforcement of the civil rights laws, to violate both clauses. Unanimous decision of the Supreme Court in 2012. So we struggle in the polity, we struggle in the culture, but the Supreme Court right now, I mean, we'll see what they do. And one of the issues of tension, and I will subside with this, is some would call it ceremonial deism or just acknowledging God in our culture. William O. Douglas, Zorach v. Clausen, accommodationist, let's let the kids out of school, or public school, early so they can have religious training. Secularists said, well, gee, that sounds like a violation of the Establishment Clause. That was 6-3, but William O. Douglas, and people can do their political analysis as to why and psychoanalyze the Supreme Court. I can't do that. All I can do is take the text of what the court says until they reverse themselves. They've not reversed themselves. And what Douglas says, we are a religious people whose institutions presuppose a supreme being. Justice Douglas, whatever his faith journey was, he understood that that's part of our culture, and we'll see what the Supreme Court does in the, quote, town of Greece, as in country, which will be argued next month, with respect to town prayer at a town council. We do struggle with that. What is the appropriateness of acknowledging the religious views and so forth, whether at football games or at other kinds of public gatherings? But my closing point is the Supreme Court is very protective of religious liberty as it pours itself into parachurch organizations.
It's interesting to me, you've all struck more positive notes than I thought you might do on where we're at with religious liberty. And I'm wondering if it's someone at the Berkeley Center thought, actually, if we put a Brit up here to moderate, we'll remind them of the Dark Ages, and we know that it's always better here. So, but EJ, I'm wondering, just to follow on from this and to go back to the mandate, the contraception mandate. And at first you objected to it, and then you said the compromise looks good. Obama's shifted the burden of providing contraception to the insurers and away from religiously affiliated institutions, and that's enough. And you also had a go at the time at Catholic bishops for striking too strident a note for some of the rhetoric around, suggesting we don't want the Catholic Church to become the Tea Party at prayer. And I'm wondering if that's still a concern for you.
More importantly, it seems to be a concern of Pope Francis. But his, and I think one of the, first of all, I love, my favorite line in the interview in La Civiltà Cattolica, translated into America, is a rebuke to pundits such as Ross and myself, where the Pope says, he who claims to have all the answers, God is not with that person. And it made me want to go on a talk show once and just say, I don't know to every question, but I might never be asked again to a talk show. I have had that concern that I think, I always like to joke that the Catholic Church's job in public life is to make everybody feel guilty about something, which proves that I'm a Catholic. Because I do think over the years, the Catholic Church challenged people who are liberal to think hard about their views on abortion, on the family, on contraception. They haven't done so well in terms of Catholic opinion. But it is, to force people to examine their consciences. Similarly, on matters of social justice and treatment of the poor, including what the state's role is in lifting up the poor, the Church has challenged progressives. And it struck me that over the last decade or so, the American Catholic hierarchy has moved sharply toward making one kind of Catholic feel a whole lot more guilty than the other, which is to say that there has been an imbalance in the way many of the bishops, not all, were talking about public issues. And that's what I saw the Pope as saying, not that he changed the Church's teachings on these matters, but when he said that there has been too much emphasis on these issues. I think he's calling us back to where the church was for a very long time on these questions. I just want to take up something Judge Starr said on the football case, because I think the football case is really interesting, because the issue, and the actual law professor here will correct me if I'm wrong, but the issue was a prayer that was voted on that would be said. And I always thought the court got that right, because it's the essence, one of the essences of religious liberty is that people in a minority, religious minority, should have their rights protected. And if in a given jurisdiction, the overwhelming majority are Catholic or Baptist or LDS or whatever you might see, a setup like that will almost certainly lead to a prayer that could offend the conscience of that person. And the other reason I find publicly prescribed prayer problematic is for all who are in any way orthodox, because you get to the point where the only prayer that could get through a majority vote would begin, Holy Mother, Father, Life Force, where then you ask, why are we doing this? And I think people who are quite orthodox would have an objection to that. But I think the football case is just again, it's so American, because the whole process of voting on a prayer before a football game, perhaps it happens in other countries and I'm not aware of it, but I'd be very surprised. Maybe you can tell me there's deep prayer at a cricket contest. But,
there is, but it's always muttered under the, under one's breath.
One sense, the prayer in the Santa Fe, which is in Texas, and it's not New Mexico, that independent school district, the record had the flavor of majoritarian oppression, so it was a Madison Federalist 10 kinds of concern. The LDS community, the Roman Catholic community was a heavily Protestant. So that's the feel you get from the record.
I'm interested in taking Ross back to something you talked about the free exercise clause and corporations, because I think it's very interesting, this case now before the Supreme Court, with the Hobby Lobby case, David Green, the owner, not wanting to provide contraception to his employees due to his religious conscience argument. And do you think corporations should be accorded a religious exemption the way individuals might be accorded?
Maybe I'll invoke the Pope Francis. I don't know. I actually, it is a very interesting area, and I suppose my instant answer is that I don't know. I don't have a clear, defined view on that, but my impulse is to side with Hobby Lobby, mostly, I think, for the reasons that EJ actually so eloquently expressed. That and this earlier in your remarks, you were talking about the contraception mandate, and you said it's unfortunate that the focus was on contraception, and that the mandate had exemptions surrounding abortion, and abortion and contraception are very different issues, and public policy should approach them in very different ways, and so on. And I completely agree with that. I worry about that idea, though, in the context of religious liberty debates, because I think it runs up against your point about the centrality of protecting religious minorities. Because in the case of sort of contraception, you are dealing with something where, let's say, the Catholic monks running a small Benedictine college or something who don't want to pay for contraceptive coverage are the definition of a small religious minority, and they're a minority within the Catholic population, as you would point out. Let's say that 70, 80, 90% of American Catholics disagree with the church's teaching on contraception and so on. And so you're dealing with a very small population. But often what I saw happening in those arguments surrounding the mandate was that fact being invoked, not by you, but by other liberals making the case for the mandate as sort of evidence that this was not actually a religious liberty issue because this was such a minority position even within the Catholic Church and so on. And the fact is, especially if it is a minority position, we should worry about, that's precisely the kind of case where you should worry about sort of state power being exercised. I think this is where, to the extent that I have a difference with Judge Starr, it's just that, I have a lot of confidence in, the American Congress not forcing Catholic hospitals to run abortion clinics, for instance, right? Because that's an area where the issue itself is so politically divisive, you have such clear, you have real political constituencies that would mobilize against that kind of thing and so on. I worry more about an issue like contraception precisely because there isn't a big constituency in defense of humana vitae in the United States Congress. As far as I know, I could be mistaken. Obviously, Rick Santorum was in the Senate for a while and so on. But I think that it's that kind of issue. And then when we look ahead to sort of the future of debates about gay marriage and so on, I think a lot of people sort of in the middle on that issue and on these debates are pretty sanguine about what will happen, in a world where gay marriage becomes sort of becomes a constitutional right, which I think it is quite likely to become, because historically it's been a very divisive issue, and you can't imagine sort of legislatures not sort of pushing back if you have overreach and so on. But given trends in public opinion on gay marriage, we're quite possibly headed towards a world where that becomes something like the view on contraception, or maybe it's 20 to 25% of the American public who's still opposed to gay marriage, and 75% who aren't. And again, those are the kind of issues where you want the First Amendment to be as capacious as possible because you're protecting minority convictions. And so that's the case in the Hobby Lobby. With that, I don't have a firm answer on the sort of corporation, sort of for-profit corporations versus charitable organizations, but I do think there is a case for erring on the side of sort of expanding protection as far as possible.
Judge Starr.
Two very brief points. Corporations do have First Amendment rights, long settled. Freedom of speech, and you say, well, oh my goodness, it must be, who wrote that one? Justice William Brennan. And those are for-profit corporations. Now, that's freedom of speech. Now, what about that which seems to be more individual, and a corporation is obviously not. However, the Hobby Lobby case is quite intriguing because while it is a for-profit, so let's move past that. For-profit corporations have First Amendment rights, settled law for a generation. Now, okay, do they have religious freedom rights? Very, very intriguing question. Does IBM have First Amendment rights? Yes, it does. Does it have religious freedom rights? We've got to think that through. Hobby Lobby is different because not only is it a privately held corporation, as I understand it, is a closely held corporation. My dear friends, this is mom and pop. So if you open up it's just their mom and pop stores have grown to be however many, 500 stores, but it's still mom and pop with a whole lot of stores, but it is completely closely held by the family. So I think we have to drill into the specific facts and appreciate that whatever the Supreme Court, if it has the case, takes that particular case, may not tell us, we'll see, that much about whether an IBM or whatever has religious freedom rights. It's kind of hard to imagine a publicly held corporation asserting such rights, but strange things happen.
EJ.
I feel much more comfortable now because I can disagree with Ross on two fronts. The first is I see allowing this exemption as just opening a door that would allow employers to claim all sorts of other rights. Why is contraception coverage different than something else? What if you have a traditional view of marriage and that women should stay home, and an employer therefore has the religious liberty to make absolutely no accommodations for female employees because he doesn't think they should be in his workplace. He can't discriminate against them in hiring, but he won't do that. The labor law, in terms of First Amendment, makes distinctions about what employers can do during union elections in order to protect the rights of employees. And so I think if this is allowed, we open up just a vast potential area of abuse where people can claim religious exemptions for all sorts of things. And I do think it's not consistent with Catholic theology, but I think a distinction between contraception and abortion is just very, very important. And just on the gay marriage question, I've been thinking about this the whole question of how are we going to get through this debate, because I do think it's inevitable over the next 30 years that gay marriage will become common because of the generational distribution of opinion on this, that young people are overwhelmingly in favor of it, and the opposition comes from older people who will eventually pass on to their eternal reward. And so the question is, how do you, as a society, protect minority rights in that circumstance? And I do think that the way in which we can settle this peaceably is to offer sufficient protections to religious institutions who do not believe gay marriage is sacramental or legitimate, and that the arguments should go on inside those institutions.
So
what I worry about,
to clarify, so if a minister isn't coerced into performing a gay marriage ceremony, therefore religious liberty isn't threatened in
correct.
any way?
And I think to a certain...
No, I don't think he was going that. You would say there could be threats to religious liberty beyond just the overt coercion.
I don't think a church hall, a church shouldn't have to rent out its hall.
But in general, if it's not coerced into providing services,
right? And that I think gays and lesbians are going to battle these issues inside. Those who are religious are going to battle these issues inside their religious institution. But to have the state recognize relationships. But the last point I wanted to make is, and this is kind of almost a plea to my friends who are sort of conservative on this issue or reluctant to go to gay marriage. What you have is a point where you can create enormous hostility that could actually threaten the very religious liberty rights that you are trying to protect. Because I think to hear some of these arguments from the point of view of gays and lesbians, they could say back, you don't want to let us live our lives the way we think we should, but you are demanding that if the law changes, we let you live your lives the way we should. And I do think that to settle a question like this, we need some reciprocity. And I worry that, I don't like culture war arguments as a general proposition. I think a lot of people have changed their minds on this on conservative grounds. They have changed their minds on this on the theory that if society wants to and should promote faithful, committed relationships, perhaps it's a bad idea to deny this opportunity to a segment of our population who happen to be gay or lesbian. And so I would like us to move down this path with as much respect for other people's views as we can. And I worry that there are ways of carrying on this debate that lead to that respect, and there are ways of carrying on that debate that lead to culture wars.
So your argument is basically religious conservatives should watch what they say, or they will be punished a generation hence.
No, they should watch what they say.
I mean, I sort of agree with you, but I think it's useful to have that clarified, right? Because I think that is sort of where we are.
Well, I guess, and people could criticize my column this morning by throwing it in my face, but a certain kind of meanness in public debate. Yes, I was kind of mean this morning. A certain kind of meanness in public debate calls forth a response. It's not that it should necessarily. I mean, we should all turn the other cheek, but we don't.
In terms of what we expect to happen, though, given what we know about human nature, I think you're quite right. But the history of these kind of debates is that, the side of the debate that is treated intolerantly, when it itself finds itself in a position of power, tends to behave intolerantly in return, right? And that's
right. And I'm suggesting I don't want that to happen, which is why I would call on people on the other side of this to think. I mean, it's the hardest thing for all of us, especially people who do what we do for a living, to put ourselves in the shoes of other people. I think this is really an issue where there are some issues that require that probably more than others. I think this is one of those issues.
But don't you think that's... sorry, go ahead.
Go ahead, please.
No.
Well, I just got to say...
While we're hanging ourselves, we're maintaining a...
No, you all are doing... I'm reminded of a comment by Gerhard Casper, then the president of Stanford University, who said at convocation, at Stanford, our goal is that all arguments will be met on the merits. And he talked about the dangers to civil society in the community of Stanford in engaging in ad hominem attacks. And regrettably, that seems to be the increasing order of the day. And that's where E.J. and Ross will do well to remind us all, kind of beat your rhetorical swords into plowshares and the culture of civility, because we have been it's been a sort of a yelling match. This hasn't affected religious liberty, but it, of course, as we all know, has deeply coarsened the culture. Even in the state of Texas, I was shocked because there is, believe it or not, a real culture of civility. And then that was not a laugh line. There's a real, people say yes, sir, and no, sir, and they're respectful. But now at town hall meetings where they're talking about bond issues, if you're in favor of a bond issue in this particular jurisdiction, you get shouted down. You're yelled down. Can you imagine? Now that is very, very dangerous, it seems to me, culturally, for a liberal society. So I must say, since I argued the same-sex marriage Proposition 8 case in the California Supreme Court, not surprisingly, welcome to the world of invective. But you take a position and so forth. But I think both sides would do well, whatever your views on traditional marriage, the church is teaching, or else a much more secularist view, or just a libertarian view. Please at least respect the motivation and intentions of the other side as being in good faith. And it's one of the dangers, I think, to a religion, because those who favor a particular social policy that's very dear to them, it's part of their essence or their, are essentially saying a pox on the entire house of religion. And to say that that's painting with, unfortunately, an overly broad brush, that the religious voice shouldn't be, and we've had a great debate on that yesterday, the religious voice shouldn't even be heard. You've got to find these neutral grounds so that I can't even talk to you. This is my friend Bruce Ackerman at the Yale Law School. I can't talk to you on, if you said, oh, so you can't, I'm not addressing this to Bruce, but to this view, so you can't talk to Martin Luther King Jr., were he here, when he speaks the language of the letter from a Birmingham jail. You can't even have a conversation until he changes his mode of discourse. I said, that's really it's completely inconsistent with human experience, but it's also just unkind.
Could I just say two quick?
Very quickly, because I would like to offer people out there chance to ask some questions.
I broadly agree with what Judge Starr just said, but I worry sometimes when the civility comes up. Not that I am anti-civility, I'm pro-civility, and I've even argued for it. But in a very uncivil way. No, but I think for this purpose, I'd like to draw a distinction, which is when you enter the public arena in any way, whether as an elected official or if you just write a lot, you invite a lot of invective from people who disagree with you. I think there's probably a little more of it now than there has been at other times. I got to say, personally, even though I don't like it, it doesn't particularly bother me, because if people are really mad about what you say, they have a right to say that, and if you don't really like having people yell filthy things at you, you might just stay out of the debate. So I don't, I'm not complaining about this. When we're talking about gay marriage, we're actually talking about something slightly different, which is groups of people demonizing each other. And that's where I would really, and maybe this is hopeless, but I would like the defenders of traditional marriage to try really hard to see how this looks from the point of view of people who are gay and lesbian, and vice versa.
Okay,
and that's where
wait a minute.
I want to make a second point, but go ahead.
Well, let's concede, because it is obviously true that the history of the debate over gay marriage has been characterized almost exclusively by invective from the conservative traditionalist side of the argument towards gay people, right? That is sort of the basic fact underlying where we are today. Given that basic fact, when you look at how the debate is playing out in the public square right now, do you think that that's the case? Do you look at the dwindling band of religious conservative voices? I can't think of a columnist for a major newspaper who is still, has written in opposition to gay marriage. Half of Fox News has said they're in favor of gay marriage. Where are you seeing
the News Standard?
Where are you? Well, no, I mean it is right. Where are you seeing conceding? And again, it's crucial to concede at this point that religious conservatives in this debate have historically sinned far more than they've been sinned against. Right now, in the balance of play, who are you criticizing? Who are the voices? I mean, you know, Jerry Falwell's dead. Pat Robertson's probably in favor of gay marriage at this point. He's come out for everything. No, I don't know. But marijuana legalization. No, but
I can't speak for Pat Robertson, right. But he is not.
He's not. No, I know. But I just don't. I just think, you know, the ground.
Well, if that's, we would have to do a
Nexus search. Yeah.
I was going to say Saint Google, my favorite new saint, but you know, if that's true, I welcome it, because I think that is the way to get to a point where we could gradually resolve this issue. The only other point I want to make is on the point about the right of religious people in the public square. I agree very much that there is the difference between church and state is not the same as the difference between religion and politics, that religion and politics have always been intermeshed in the United States. And you can go through a long list of causes I admire, from opposition to slavery to civil rights to social justice, where religious voices have been central and who have often spoken in a religious idiom. I think there's another tension here, which is, I do think in a pluralistic society, one has every right to base one's conclusions on religious convictions and to explain why. But I also think there is an obligation to argue for your position in terms that are accessible to people who don't agree with you. That's not a constitutional obligation. Mm-hmm. I just think it's an obligation of a pluralistic society. So I can't say to a conservative, you should vote for this welfare bill I am for because Jesus said so. Now, you can argue about
An
whether
argument is actually like the only one that ever works on me, though.
Yeah,
so I don't know why you wouldn't.
No, I'd have to make it more complicated, right. But I probably would disguise it. But I think that's problematic, and the same is true. You have to oppose abortion because of this. I think there are other arguments that people can have about abortion. So it's a matter of right, which people have, and a matter of etiquette, and something more than etiquette in a pluralistic society.
Thank you. I think we'll draw a line there. Just if you're looking for the invective that you said it's not out there anymore, I was just reading a piece Ross wrote on religious liberty in the gay marriage context, and your suggestion that we shouldn't fight this as a war, we should negotiate terms. There were a lot of comments afterwards of people going at each other. And one comment I even quoted here from the secularist side, which I thought was interesting, given the tenor of debate and the way people are framing things. Why is it when I hear arguments for more religious freedom, it's always freedom to discriminate? That at least is often the perception out there, don't you think?
Well, I lament that because, you know, you spoke of Pope Francis and other evangelical leaders of the past generation have been lifted up. But there is quite a growing cadre of evangelical leaders who are saying the preferential position of the poor has much to commit. Isn't that sort of what we were taught? The evangelicals are creatures of the book or students of the book. And so when you read books such as Rick Stearns' Head of World Vision, which does mighty and efficient work, and they execute extremely well. They execute far better than most organizations in getting relief to the poor and the needy. I cite as authority CNN on the Haitian earthquake. Who was there quickest with the most? It was World Vision. And read A Hole in Our Gospel, not in the Gospel, by Rich Stearns. I could go on. Rick Warren was here on this very podium speaking about the Catholic evangelical dialogue with Robert George from Princeton. And this is who evangelicals are these days. Of course, you have views on morality that are grounded in biblical teaching, and we don't apologize for that, but we also say something has been missing, and so this is why Rick Warren at Saddleback Church talks with President Clinton, talks with Tony Blair, why they work together on things like Rwanda. That's the other side, which I think evangelicals And Catholics need to talk about.
Which is maybe not as emphasized as, the culture wars subjects that
But
we're talking about
it is
today.
also, I mean, it's bad policy for a columnist to respond to the internet comments, but
Sure,
I'll
no,
make an exception in this case and just say that the commenter has a point, right? That in fact, the big debates probably facing us over religious liberty in the next 50 years are debates about whether religious institutions have the right to, it's not always discriminate sort of per se, but to do things in that vein and to sort of set standards in their own community that would not, that do not match with sort of the more egalitarian and, let's say sort of morally, I don't want to say morally permissive, morally, non-Orthodox Christian, whatever phrase you want to use, of the culture as a whole. And this is always the tension in a pluralistic society, that between these sort of groups that you have a sort of egalitarian frame, but then the society also depends on groups that, frankly, set aside the issues of sex we're talking about right now, groups always depend on their ability to discriminate, whether it's the Elks Club or the Knights of Columbus or the Masons or whoever. And that's sort of, you go back to Tocqueville, that's part of sort of the genius of America, has been our ability to maintain this sort of formal egalitarianism combined with sort of, a sort of pluralism of a multiplicity of communities. And so it's natural that that's sort of where the debate happens, even though, of course, there are broader issues, and of course, the deeper thing is that, I mean, I guess to sort of link my comments to Judge Starr's, one of the pragmatic reasons that sort of more, let's say, secularist voices should pay attention to and respect some form of, rights of discrimination within religious communities, whatever you want to call them, is precisely because of the contribution that those kind of exclusive communities make and have made historically. That you want that maybe instead of calling them exclusive communities, you can say intentional communities, right? That it is intentional communities of people bound together by a common purpose that inevitably means excluding people who aren't bound together by that purpose, that has historically made a huge difference in sort of the ordinary lives of Americans. And of course there's a balance, and there are forms of discrimination that you can't allow, and the question is where you draw the line. But again, I just don't think it's surprising that that's where the debate would be.
I know EJ wants to say something, but no, he can't. This is where I have to put my foot down. But he's such a professional. I know he's such a professional that he'll be able to wrap it into an answer that to a question that someone might want to pose from the floor. So if I could ask you to briefly introduce yourself and then pose it in the form of a brief question. This lady here.
I'm Roberta Williams.
Oh, just one moment, sorry. Wait for the mic.
On my way to my just reward, I hope.
We missed your name.
I don't want my just reward. I want some
Roberta
other kind.
Williams. Okay. It's only by his mercy, excuse me. I just want to read something that appeared in the Catholic Register and ask the three panelists what they think that implies for the trend in our government. On a May 13 letter from 72 members of Congress to Hagel, first circulated by Lamborn, expressed concerns about a growing pattern of hostility toward Christians in the military. It told of an Army PowerPoint presentation on equal opportunity that included evangelicals, Catholics, Mormons, Sunni Muslims, and some Jews on a list of extremist groups, along with Al-Qaeda and Hamas. The letter backed language in the National Defense Authorization Act that defends religious liberty in the military. President Obama, who said when signing the 2013 Defense Authorization Act that such language was unnecessary and ill-advised, has threatened to veto the 2014 version of the bill if the religious liberty language is retained. Now, this was published by in an article written by Wayne Laugenstein in the National Catholic Register on the 18th of this month. It's on email, and I opened it up to them.
EJ.
Well, what I should say is invoke Pope Francis and say, I am unaware of this controversy, but I got to say that surprises me, and I am very curious what is actually underneath that. It feels a slightly distorted account to me because of what my experience of knowledge of the military through my sister who served, and it's funny you raise this because just this week I was having a conversation with an Air Force major, and I asked her about the other side of it, which is a lot of people in the Air Force have seen heavy pressure from the evangelical side, or have spoken of heavy pressure from the evangelical side, and obviously every person has a right to be evangelical to convert someone, but it gets very complicated in a chain of command because it can become a kind of pressure that's illegitimate. And she was arguing that she did not see a lot of that, but she made the point that and she was religious herself, that the sort of overwhelming number of people she served with were religious, expressed religious views, and clearly did not see their religious rights as religious people under threat. So I would be very curious. Jane said I would be very artful about adding my other comment. I'll be very inartful because there are just 3 quick sentences I wanted to speak in response. Yeah, I do think that the question you asked, Ross, it sort of raises, I broadly agree with the commenter, but I think, one question is, do you emphasize a God of mercy or a God of judgment whose judgments always coincide with yours? And I think that's
not for the state to decide.
No, but I'm talking about, but this wasn't about the state. This was about people in conversation.
Okay.
Right.
And the second is about Pope Francis, where it seems to me that he has shifted the emphasis somewhat to a God of mercy. And who in the world ever expected a pope to say, "Who am I to judge?" A lot of people thought that's what a pope did for a living. And it does suggest a kind of open spirit where I'm not sure he might have a dialogue with the person who wrote that comment back to Ross.
Very nice.
Could I
Can I just ask for another question, and then
Judge
you can
Starr may
respond?
actually know something about the question.
Okay, very briefly, and then we'll get some more questions in, and you can
Horror
respond.
stories like this, I simply accept the text as you read it, will happen. But I think you noted something very interesting. X number of congresspersons rose up in righteous indignation. The fact that the story may be playing out, I think if anything it should be, of course horror stories are going to happen. And so what happens? If we simply say as a society, ho-hum, that's just the march of the secularist, sort of egalitarian, and really, not just secularist, but anti-religious, I think Congress and others, the pundits want, with a couple of exceptions, they may even be applauding. But American society continues to be very hostile to those who are hostile to religious liberty. Is that changing? I really don't think so.
But I think crying wolf in this conversation is very dangerous. Now, again, I have to know more about this case. But we do know that there have been extremists in every religion, including our own, whom we, as members of that tradition, would disagree with. So I don't know what this regulation looks like, but I do worry that crying wolf actually ends up undercutting the rights of religious people.
Another question? This gentleman over here.
David Novak, University of Toronto, and Religious Freedom Project. I'd like to present a much harder case to the panel. After all, we've been mostly talking about the question of Obamacare and exempting people. And if you think about it, exempting people from whether people should have to pay for something, not being mandated to do that, but just to pay for it indirectly, for also people who are not being mandated to do it, but are giving a right. A much harder case is the question of what is referred to as ritual or religious circumcision. Considering the recent ruling of a German court, considering the referendum, was it last year, about a year and a half ago in San Francisco, and this is being presented as a civil rights issue, that basically, that if my parents, when I was 8 days old, subjected me to circumcision, that they committed a harm against me, and therefore this is something that ought to be disallowed on civil rights issues. And yet religious groups say that basically that if we cannot circumcise our sons, then the question is, can we be a part of this society in good faith? This is going to be raised. The issue has already been raised in the German courts. I'm sure it's going to hit the American courts. I'd like to hear what you three gentlemen have to say on that issue.
I'm delighted you brought that case up. It's a very interesting one from Germany.
David, you win. The German courts, and we're seeing this throughout Europe, genuine hostility to religious right and practice. It's at least a couple of centuries old in France, but in our country, welcome to liberty is the baseline. I think that is the fundamental teaching of the First Amendment in all of those fundamental liberties. Liberty is the baseline, and including the liberty of parents to raise their children, and this includes to inculcate them and to, unless there is what? A compelling public health reason that would justify, for example, I'm sorry, Mr. Jacobson, real case, Jacobson versus Commonwealth of Massachusetts, you must go get your smallpox vaccination. I'm opposed to it. Freedom of religion. I'm sorry, roll up your sleeve, get ready, here it comes. So in this country, I am confident that at least in my lifetime, which may not be long, that kind of religious practice that is rooted in tradition, so exactly what are the facts? I mean, it's rooted in sacred tradition, is not snake handling, is not starving the child, feeding the child only lettuce or whatever, denying the child access to health care, where real parens patriae issues become, it seems to me, compelling. But the baseline is freedom. I think you're protected, and I think, I'm not familiar with the San Francisco ordinance, but those kinds of ordinances, I think, will fall, at least at the Supreme Court of the United States, if not before.
Could I ask you a question? Because I agree with that, and I don't think this would stand in the United States. But there's a more interesting case in New York City, as you know, it's not a legal case yet, about a form of circumcision used by, I believe, certain Hasidic sects. Can you describe that, partly because I'm trying to get out of describing it, but also because I don't want to misdescribe it?
It is a practice that a certain amount of blood is drawn out by mouth. And it is a question, fortunately, there is plenty of opinion in the Jewish tradition that this need not be done. But for those who claim in the Hasidic community that this need be done is an issue. But the complaint about it is that it transfers disease. That is the point. Not that it happens to be aesthetically
correct,
unpleasing. So in that sense, that's interesting. And that would be an interesting question because then the courts would have to decide clearly. Whereas when it comes to circumcision, there's nobody within the Jewish community who would say, well, we can waive it, unless it's a question of a hemophiliac or something like that. But in this question where there's debate within the tradition, then it's very interesting because then the courts could say, well, everybody within the normative Jewish tradition, I'm not just talking about Jewish opinion, could do otherwise. That would be a very, very interesting case to see if it hit the courts.
But could I just say two things? First, thank you for describing it so I didn't have to. If you were in the Catholic tradition, I would say you just got rid of many years in purgatory for that mitzvah. So thank you very, very much. But the reason I raised
that's very generous of you.
What? I'm sorry?
That's very generous of you.
Yeah, no, but it's good of you.
EJ hands out indulgences like they're going
yeah, don't bother to pay for them.
Absolvo te.
The reason I raised that case is because I think the first case does not seem to me to raise any difficulty in asserting religious liberty. But the second one is really complicated because on the one hand, there is a legitimate public health issue, yet this religious minority that makes this part of their practice would say that we, who would say, my God, this is should be against the public health code, it should be enforced, they too would make a case that this is and have made a case that this is a violation of their religious liberties, and it's actually come up in the New York City mayoral campaign, as you know. And that's the hard one, and that's where I think the balancing act inherent in the First Amendment sort of hits us all the time.
Well, I mean, the interesting thing in terms of circumcision is that the argument against it is not just this is optional, but that circumcision is actually a harm. I mean, there's a whole anti-circumcision movement in terms of just medical circumcision, irrespective of religion. And this becomes the problem. Are you going to exempt people from what is, at least some have tried to argue, is a harm to the child. In other
Well,
words,
then it
are you going to
becomes-
allow Christian Science parents
Very
not to
briefly,
take
and
their
then I'm
child to
going to ask
adopt?
Well, then it just
couple more
becomes a
questions,
matter
yeah.
of facts, if I may say so, because the Christian Science cases have all been, it's settled. You can't do harm to the child, so what is the harm? And that's a tribal fact.
But that's where I would disagree a little, in the sense that I think all of these facts, I mean, obviously there are clear cases where, you know, if you cut off your child's legs or something, almost nobody's going to argue you aren't doing them harm and so on. But the gray areas are conditioned by sort of cultural attitudes, right? And this is why the rearing of children is, I mean, it sort of goes back to the point I started with, that, you know, what does the exercise mean, right? What does free exercise mean? That's sort of the whole ball game. And as cultural norms shift, how people approach that will shift. And you can, you know, you've had arguments made in the European context, but also in the American context, that, you know, if you're religiously conservative parents, you know, raising a gay child, that teaching them traditional Christian views about sexuality amounts to a form of sort of psychological warfare against the child that has sort of definitive harms and so on. So I wouldn't be so quick to say it's just sort of the medical facts of the case, because, you know, if you dropped into a society that had never heard of Jews or circumcision or the law of Moses and said, hey, there's this religious sect that cuts off the tip of every male child's penis, do you think that that's a public health harm? I think a lot of people would just, you know, raise their eyebrows and say, well, yes, it is. And I think that's precisely why these issues are so fraught.
Can I move on and ask for a couple of questions at the same time, as short as you can? We're going to try and get in as many questions as we can at this stage. So if there's two people here close together, if you'd like to briefly introduce yourself, and very brief questions, please.
Nick Walterstorff, retired philosophy professor, I guess that's
I cede all my time
that
to
will
professor,
do,
to the distinguished professor.
about the quip that why did the religious freedom cases always involve the right to discriminate? That strikes me as a wildly mistaken and pejorative description. Judge Starr can give lots of examples, but just take one of them. The Rosenberger case at the University of Virginia, the right of a religiously oriented student newspaper to funds that are distributed to newspapers in general. That's not the right to discriminate. So
I think the commenter just meant the ones I tend to write about, honestly.
Yeah, the ones that are really,
I'll take some responsibility.
then what they should say is, why does Douthat only write about such cases?
Say that too.
And
Thank
the
you.
University of Virginia case, and that was one of those Supreme Court teaching moments. Now, the court was divided there, but it was divided on the principle of Madisonian's memorial and remonstrance, not 3 pence should go to support a religious voice. And Wide Awake, the name of the journal, was indeed an openly religious voice. Clearly, there was absolutely no compromising that it was evangelical Christian. It may have been broader than that, but it clearly was organized by deeply religious evangelical Christians. And this court struggled, even though the majority said, of course, equality, equality, equality. The student fund funds any number of student journals, and therefore you cannot withhold funds from Wide Awake. Again, I think we need to look carefully at the dissent and say, even there, can we find common ground? And that's the concern about, we haven't talked about that, financing,
Right.
quote, religious activity and financing religious voices. And that is a hard one, I think, under the establishment.
And it makes a difference that UVA is a public university.
Oh,
that
yeah,
it-
I'm sorry. The only reason that it was, exactly.
However the case is decided, I think it was decided right. It was not, the student newspaper was not pleading for the right to discriminate.
No. It was just its voice, its
But
worldview.
the student group that lost at the court recently, the Christian group at which it was a California...
Hastings.
Right. I should have known that's where my dad went to law school. Yeah, right. They were asking effectively for the right to choose their own membership, and because they were an official, I may be getting this wrong, but
No,
because
you're
they were
getting it
an
right.
official student group, that right was denied. And this is where, again, I completely agree, this isn't sort of the range of religious liberty cases and issues, but it is where the conflict tends to be right now. And it is precisely because, this goes beyond student groups, so many universities, charities, hospitals are deeply entangled with federal and state spending in all kinds of ways. Even if you're a private university, if you were suddenly, I mean, there's a reason that Bob Jones University is always talked about as this example, because it is a big deal for colleges and universities to be cut off from public dollars. It is a big deal. Catholic charities could not function without being, without public funding. And I mean, maybe that's a problem for the sort of Catholic side of Catholic charities, that it's, but anyway, I just think that there is I guess I'm defending the comment.
Can I
hang on, we've got a couple more questions to fit in. So this lady here, and if you'd like to indicate before you speak, if anybody else is desperate to ask a question, hand up now, and then we'll move on. Okay, we'll have one question here.
Hi, I'm Rebecca Downs. I'm with the Institute on Religion and Democracy. And I wanted to mention the Hobby Lobby case. We discussed, do corporations have rights? And I think, as Ken Starr mentioned, but I think the heart of the matter is that people run corporations. That's why I don't think it would be so strange for them to have religious freedom. So I wanted to know if you wanted to comment on that.
Yeah, but they have I'm sorry.
Go ahead.
But they have chosen to do business in a corporate form, and so the case is Hobby Lobby Corporation. So it is a neat question. You are at least one step away. You are invoking, and this is the argument on the other side, you're invoking and welcoming all the privileges, including limited liability, for the corporate form, and therefore doesn't that, the argument goes, give the government more authority to regulate? And I think it's a tough question. To me, it's a fairly easy question with respect to large publicly held corporations, notwithstanding freedom of speech, given the nature. I mean, I shouldn't say it's easier. It strikes me as easier than when you have, and I really want to emphasize, this is a closely held corporation. Literally, these members of the family and only those members of the family on the corporation. So it's mom and pop. And therefore, I think they are at the zenith of the right to assert their individual rights. If they start selling stock, it gets diluted, so to speak.
I'm sorry to interrupt, but apparently we only have half an hour for lunch, and I know some people do need to eat at lunchtime. So I'm going to ask this one gentleman over here for one last question.
Hello, my name is Jacob Rudolfsson. I come from Sweden, the Swedish Evangelical Alliance, and I just think.
Man.
Sorry. Yeah. I'll tell you what's going on here. I just find it very strange that it is the talk here is on that it seems like it's only religious groups that discriminate, but secular groups discriminate also. For example, in Sweden you have the a discussion on why the Salvation Army won't allow same-sex couples be officers, but the Social Democratic Party won't allow moderates to be part of their board. So you have secular institutions that also discriminate against other people that don't share their ideology. So it's kind of strange that we put such a negative sense on discrimination, because we discriminate all the time.
Jane, may I comment? This is a wonderful way to end this conversation, not my comment, but that question, because I wish I hadn't said that. We have worked our way through a lot of the religious freedom grounds. Not all of them, there are always going to be questions. We have not worked our way through freedom of association. And Ross said something very powerful. One sentence that he said was, the right to exclude. That sounds really unfriendly. It sounds hostile. It sounds unwelcoming. What happened to the welcome wagon spirit? But the very nature of that organization cries out for the ability to say, I'm sorry, you're not welcome. So I'll use the silly hypothetical. The KKK member says, may I join the NAACP? So I'm figuring what's going on. The answer is no. What is it that you don't understand about no? You're not here. Why? Because you don't share our set of values and worldviews. That is fundamental to the freedom of association, which is actually textually based in the First Amendment, although tied to peaceably assemble to petition the government for a redress of grievances. But we haven't worked our way through that jurisprudentially very well yet. And Hastings, which Ross, the Hastings Law School case, was one of those bad facts makes really bad law. We don't have time to go into it, but the point is we need to do lots of thinking about friends, the freedom of association means the LDS Church gets to define who its members are. The Roman Catholic Church, ditto. And please don't tell me that you have a human right to join that organization or institution. That the right that we enjoy really is a matter of human dignity. And Tocquevillian is the ability to define the contours of the group.
3 real fast points. One on just to your point about people run corporations. People also work for corporations. And I think that this Hobby Lobby case raises some real issues for the people who work for corporations. On this last point, we have agreed that there are certain forms of discrimination that are not legitimate. I cannot and should not be able to, in my view, discriminate about who I sell my house to. That's a very personal decision, who I sell my house to, but I cannot discriminate on the grounds of race or religion, and I think that is a legitimate role for the state. And a lot of these questions do not come up. Can the Social Democratic Party in Sweden expel a member who says, I am a supporter of the American Tea Party? Because that is about freedom of association within a political party. But it would get more complicated if a government run by the Swedish Social Democrats actively discriminated in illegitimate ways against this person. So the state is involved. And that's where I just wanted to get to Professor Waltersdorf's question about the publication. And this is the last comment I want to make. And this is almost a Baylor separationist kind of comment. The First Amendment treats religion in a special way. We as a nation have given special rights to religious institutions because we so value religious freedom. The question is, does that end up having...
Wait, who is giving
the
them
state?
these
The
rights?
Constitution gives, I believe, special rights, specifically enumerated right in the First Amendment. The
right.
question is, does that come with certain obligations on the other side of the First Amendment? We also say that we do not want government subvention of my proselytization on behalf of Catholicism or someone else's proselytization on behalf of evangelicalism and so on. And I think what we're seeing sometimes is having it both ways on the First Amendment. We want all the privileges that the First Amendment accords, and we won't accept any of the restrictions. And when you get to cases like a publication like this in public universities, I'd probably be pretty permissive about student funds, because I'd also worry that does this let them exclude a Marxist publication? Right. You know, so I'd be fairly expansive, but it is public money, and I think that raises a legitimate concern.
Thank you very much. One last thing, Ross, you started this conversation as a cautious pessimist. Are you still a cautious pessimist on religious liberty, or are you a convert?
No, I mean, I'm a huge pessimist only because I'm looking forward to at least a decade of being on panels with EJ, quoting Pope Francis against me in one way, shape, or form.
I went through a long time on the other side of that.
But but no, I don't really have a sort of brilliant ending. I'll just two small points. Just that a point of agreement with EJ, particularly as it relates to my semi-agnosticism about the Hobby Lobby case, which is that what the whole fraughtness of this is that clearly not everything a religious person does counts as the free exercise of religion. And I, as EJ says, I cannot say I refuse to sell my wife. Sell my house. Is this on tape? This is on tape. Sell my house. Now I don't know how to finish the sentence. I can't refuse to sell my house to an African American because of it's the free exercise of religion, the sale of my house. And so there is a gray area there that courts and legislatures and the culture have to adjudicate. The only thing I would say as a sort of concluding point of rebuttal is that the reason that in some of these cases the rights of the employee get less shrift from sort of people focused on religious freedom is because there isn't as much of a sort of constitutional issue at play. There is not a constitutional right to have your employer pay for X amount of healthcare. That is a matter of sort of legitimate public policy debate, but it isn't a constitutional question in quite the same way that the religious freedom of the employer is. It doesn't mean that the two don't need to be balanced, but there is a greater constitutional stress on religious freedom than on, since we are at Georgetown, the particular rights of Sandra Fluke to have particular forms of birth control provided by an employer or university. And that's just, I think, the tension that you're sweeping under the rug a little bit, but only a little bit.
Well, I think we have a conference right to lunch, so I'm afraid we're going to have to bring it to a close there. I wish we had another week for this, but it was fascinating. Thank you all very much.
Thank you so much.